Hello.
Hello. Can you see me?
Can you- I can see you. Can you hear me nicely?
Of course, I can hear you. Whew, what a day.
Hi, welcome.
What a day. What a day. How's your day?
Also, just as hectic, but I'm good.
Right.
I wish I could show you my background, but the lighting is gonna be bad.
This is. Don't you have your ring
Yeah.
light today?
Yeah.
Don't you have your ring lights
I
today?
do. I do. I do. I do. Hey, how's Will's week going?
It's hectic. I just finished the wall now, and I have another one straight after this. So I think it's good. People are taking advantage of the free service that is provided, and
Yeah.
people are starting to wake up. Like now,
Okay.
yeah, they are starting to wake up and they're starting to realize that okay, wills are actually very important. So
Okay.
I am I'm not complaining. Yeah,
Okay.
yeah. It's just obviously a lot of work,
Okay.
quite a bit of drafting, but I
I
have
think we
no
just had
complaints.
load shedding here.
Is it okay?
Thank
But
God
I
for the
can still,
light.
yeah, I can still see you perfectly.
Yeah.
So yeah, that's Will's week. It's quite hectic. It's also quite emotional because now you have to make people think, and they're thinking about death. And when people are thinking about death, it's like, and then
Mm.
so yeah, some of them they take a while. They take conversations can take a while too because some people. I remember the lady who just started crying. She just broke down and I'm like, oh my gosh, let me close my
Oh,
because the last
I
thing you
can
want to do is
imagine.
the last thing you want to do is think about your kids without a mother.
Yeah, exactly.
Mm,
Without you.
mm,
Or just think about yourself not on earth. How is
mm.
that possible? Where are you gonna
You see,
be?
where you going? Who's going to be your husband's wife or so
Yo,
yeah. So it's quite
yo, trauma.
mm, so that's what we're going
But
through
at
this.
least that's better. Working in my space now, there's this term that says, um, you don't want to boil an ocean, or you're not trying to boil an ocean, or whatever. So the little bit that you do is enough. Is
True.
it's sufficient. Yes, it
Mm,
might not be everybody that gets it now, because everybody
yeah,
will, the pin drops when it drops.
that's true.
So, but I think you're doing a good job.
Mm,
The little bit that you're touching, the little bit that you are helping, it's great. It's
mm,
great.
yeah, no, you're
It's
right.
great. Eventually, the ocean will boil itself, I guess.
Exactly, you know what I mean? Yeah, that's true. That's very
Yeah.
true.
So I think my interest, now my worry with my podcast is how we relate to one another. Firstly, how we
Mm,
relate with ourselves, and then
mm,
how we relate to one another. So I think my thing is about if we can treat each other with a little bit more grace, or well, if we can understand each other and respect each
mm,
other, I think we'll be more graceful. And things like these are exactly that. Do you think
yeah.
about me? Do you think about I'm gonna be in a tight situation if you don't do anything about this, if you don't plan your estate, if you don't plan your life,
Mm,
if you're my partner or you're my mother, then I
mm,
end up in a situation where it's just not favorable.
that's true. That's true. I
Yeah.
think
So
it goes down to the idea of being considerate as well. Um,
yes.
because yes, you could be living alone, but you're not an island.
Yeah,
Everything that you
definitely.
do, everything that you do affects the next person, always. Whether
Always.
it's someone that's going to inherit, whether they're not going to inherit, they are always going to be affected. So,
Yeah, either way. And that causes a lot
mm,
of conflict. And that's where my problem is. Trying to
that's
reduce the conflict, unnecessary conflicts
mm,
you can avoid, you can proactively plan to avoid.
mm,
I mean, already there's a lot as it is. I mean, if there's things that you can manage them now. I think, yeah.
top. If someone comes to me and say, "Why do you need a will? Why don't you need a will? Why don't I need to start planning? Why not? Because if you can do it and you're alive and you've got the opportunity, and then
Mm,
take it. Rather,
mm,
rather, they say, I don't know, kakasipedi. This, but I'll just translate it in English. It says
Mm,
that um, no one will know what you want when you're dead.
mm,
Um, so rather put it down on paper or
mm,
actions now, so that it can speak
mm,
to those who are still there when you're no longer.
mm. Okay. So you're gonna tell us all about it. I think my lights are back on.
Hmm.
Thank God my Wi-Fi didn't drop.
Yeah. Oh, it's a nice. It's okay. So where do we start? Wills.
Wills, baby.
Okay. So actually, let me take it back a bit, because I think the big umbrella here is estate planning, right?
Yes. Mm-hmm.
Estate planning comes with a lot of tools, right? And these are tools that will affect your estate planning journey. So, what's estate planning? Estate planning is a journey you go into to protect, to minimize, and to maximize your
Mm,
wealth, to minimize
mm,
taxes, to minimize
mm,
risks, and then to
mm,
protect, obviously, your assets for your beneficiaries.
mm.
Um, so the estate plan, like I said, has a lot of tools, right? So if you're looking at tools, for instance, a will is a tool. Drafting a last will and testament is a tool of estate planning, right? So you cannot say to someone, I am estate planning, but you don't have a will,
Okay. That's where
right?
we start.
It's not even where you start, but it's a tool. So you can't even, it's not like one, you pick one and you can leave the others. You can
Yes.
it's a journey, you know
Okay.
what I mean? Depending on
Okay.
your
Okay.
reasoning, the assets that you
Okay.
have, your beneficiaries, right?
Yes.
Then another tool would be
Yes.
your antenuptial contracts, your marital regimes, right? That's a tool,
Yes.
right?
Yes.
Getting into
Yes.
that is a estate planning tool, because why? It affects your money, it affects your assets, right? And remember,
Yes.
one of the reasons, or one of the explanations of estate planning was protect, right? And what does antenuptial do? It protects your assets, or it protects creditors from the home, right? So
Mm-hmm.
that's another
Mm-hmm.
tool. A second tool would be, or another tool would be trusts, creating a trust, right?
Mm-hmm.
What is a trust there for? A trust is a entity that is created to house or to own assets for the benefit of beneficiaries, right? So that
Mm-hmm.
then becomes their assets. That it becomes a trust
Mm-hmm.
asset, no longer becomes your asset, right? Reason why it's that's also another protection, element of protection that the trust
Mm-hmm.
does. It's a tool, it's a protective
Mm-hmm.
tool, right?
Mm-hmm.
Then there's for instance now your taxes, right? So your tax
Mm-hmm.
consultants are also very big tools in your in your
Okay.
estate planning, because they're the ones who come and say, okay, you want to donate money to Mang Mang, right? How do you donate the
Yeah.
money without incurring donations tax?
Mm.
You know,
Okay.
and I always say
Okay.
that your estate planning journey needs to have a team of people, right? You need to have an
Okay.
attorney, you need to have
Mm-hmm.
a an accountant, you need to have a tax
Mm-hmm.
practitioner. Sometimes an accountant and tax practitioner can be one person. That's fine. And you obviously need
Mm-hmm.
someone that can help you with, your monies, your, financial advisor, whoever, who is able to say, okay,
Financial advisor. Yeah.
try this. Oh, okay, no, there's this really nice uh, take out this policy, for instance.
Product.
Exactly. So they would be
Mm,
selling
mm,
products,
mm,
or, but it's basically people who are there in your circle, in your team, who are there to
mm,
maximize,
mm,
protect um
mm.
your assets.
Okay. So you said it's an attorney, tax practitioner, financial advisor. What else? I missed one.
Accountant.
Accountant. Oh,
Mm.
the tax practitioner and the accountant could be the same person.
It could be the same person, or it could be two different people, depending on,
Yeah.
obviously, what their professional journey is.
But how much money do you need to think you have? Because I think maybe another perception around estate planning is around, do I even have anything to plan? Do I even have the money to plan? Is that right or not?
I
Where people
mean,
think, I don't even have a car to my name or a house. What the hell am
mm,
I claiming?
but do you have a bank account? Does it have cash? Do you have a pension fund?
Yeah.
Do you have liabilities? Do you have debts? Because when you die, who's going to pay your debts?
Mm.
What happens then?
How can we insure the debt? We take the debt and we take the
Exactly. So
insurance
now
for the
that process
debt.
of the
Mm,
insurance paying over your debt, that's a deceased estate process that happens, right? So there must be somebody who is administering your estate, which is in
mm.
this case, which is an executor, right? So your executor will make sure
Yes,
that
yes,
the
yes.
insurance pays over this debt and then closes that
Mm.
account, and so it doesn't matter if you look. I believe you need to have a will from the day you turn 18. Guys, if you've got
What
a
else?
tlhako, or you've got a dress, o na le diaparo, o na le eng, and you want to put
That's
down, okay,
enough.
I want my sister to have this. That's enough. I remember
Okay, I
when
get you.
the first time when I was participating in Wolves Week, I think it was about 3 years ago, and I had a 25-year, 23, 23, 20, he was between 23 and 25. I don't remember how old he was, and
Mm.
he was giving away his sneakers. So he was like,
Okay,
I want my sneakers to go. These are my most expensive sneakers, and he had like a list of them, and
okay,
he'd be like, I want my to my best friend, and the
okay,
other one can go to him because
okay,
I mean, that's the stuff that he
okay.
values. He
Yes,
valued his
yes,
sneakers. So when you value something,
definitely.
you want it to end up where it's going to be valued the same way. That's how he looked at it.
Where you're going to be happy, where you also wanted to land and you're going to be happy.
Exactly.
Okay. So let's start with what is the order? Will. First thing is the will. Because we
Okay, so if
spoke
you get
will,
married, if you're
antenuptial
getting
agreement.
married, so if you're getting
We
married,
start with the
it's
antenuptial agreement.
you'd get an international agreement, and then when you have a will, then you two of you individually have to do your own wills, right? If you're in
Yeah.
business, for instance, then you have what we call a business succession plan, right? Those are for
Okay.
people who are self-employed because end of the day, when you die, are you gonna die with your company? What's gonna happen after that?
Okay. Okay. So let's start with wills. And first, maybe when you're not married, when you're married, then
Yeah. So
okay.
okay, wills. So where
Wills.
do you start with wills? So the first thing you have to realize is that it's a very bad idea to always do a will with a financial institution. I know I don't want to be anti like banks and stuff, but it's it's such a bad idea because if you
Why?
have done a will with a financial institution, go check who the executor of that will is.
Mm.
It's
It's
always
probably one of
themselves.
the, yeah, themselves. Yeah.
Hmm. And you actually allowed to pick anyone to be your executor. The executor is
Yeah.
the key stakeholder of any will or
Mm.
uh, uh, any deceased estate. So you die tomorrow, right?
Mm.
The executor is the one
Mm.
that goes and reports the estate to the master.
Mm.
They then wind it up. They, based on
Mm.
whatever your will says, are the ones who are able to make sure that everything is up to your requests. Whatever
Mm.
assets go here, whatever tracksuit needs to go to your sister or this, they make sure that that gets done. So that's their job is there to wind up the estate, right?
Mm.
So the
Mm.
executor is also a very it's a very important person because they also determine the time frame of
Mm.
your winding up. So normally with financial institutions, you
Mm.
see they can take like years to finish,
Mm.
right?
And you
Why?
pay.
I'm coming there. I'm coming there. I'm coming there.
All right.
Why? Why are they taking years? Number
Mm.
two, the executor by default, as the fee for their work, they get
Mm.
3.5% of their assets. So as of the net value of your estate. So
How much
yes, you can get 3.5%.
of the value of the estate?
Yes, and then 6% for all the income that comes in.
For what?
Income. So say for instance, you
Okay.
want your business to continue running, and then there's income that's
Yes.
coming into your account, right?
Okay.
They can get
Okay.
six
Okay.
percent of every, even like things like rentals. If there's a property that's still in your name, it has been transferred, and there's it's
Wow.
getting, they get 6% of that.
When does that stop?
When does the never?
Never.
Well, when your estate is winded up, when it's finished, basically, when you're done.
So what would happen if I have maybe rental? So that means until that house is sold, then that's when they stop.
Or exactly, so sold or transferred according to your will, and then if you don't have a will, according to the Interstate Succession Act rules. So if your spouse, your children need to inherit, and but it always needs to get out of your deceased estate.
Nay.
Yes, it has to get out of your name. Someone has to own it. Whether it's going to be sold, whether you're insolvent, whether the bank takes it back, whether it's going to have to get out and go back to the owner,
So they will take the 6% of every income monthly.
basically,
And
until it's gone.
then also when it gets sold or it needs to be transferred, um, then there's a fee for that as well, I
Of course,
guess.
transfer fees.
Yes. All right.
I know, I know.
So,
That's where the banks benefit. Do you see?
so who must we appoint?
Your family members. You appoint someone you trust. You appoint someone that can do the work. You appoint an attorney that can do it properly. Because at the end of the day, the biggest aim would be to wind up your estate fast, right?
Mm,
So that whoever
mm,
is owed what can get it.
mm,
So you're basically, that 3.5% is, it's their fee. It's their salary
mm.
basically. Yeah.
But now, how much work is in that rounding up of an estate? I'm thinking which family member, I mean, how much work is in there?
It's a lot. And if your
Yeah.
estate is over 250,000 rand, you actually need an attorney. They actually tell
If
you
it's
you must
over
get an attorney.
250.
Yes, you need to go get an attorney to help you, because then you do what they call a liquidation and distribution account, which is
Mm.
a accounting. It's an accounting formula of how, okay, you've got assets, liabilities minus that, nah, nah, nah. Then it at the end you'll see where everything's distributed, how it's distributed.
And your family member, if they get to this point, they can still appoint an attorney.
Yeah, no, of course, yeah, they can, but
Okay.
they would not be able to get to that point without an attorney.
And that's the problem. Don't now what are you
Mm.
saying about the family member? Do they know how? Do they even know where to start?
But remember, they would
Mm,
be so what they'll do is that they would be the executor, right? But
yeah.
then they'd hire as an agent an attorney, right?
Okay.
And then pay the attorney whatever, but they'll still get their
Mm.
3.5.
Who's this now getting 3.5?
The executor, the family member.
The family member. Or they will
Yes.
also be allocated the money.
They'll be allocated the 3.5. Then they will, because as an
Oh,
executor, you're allowed to get someone else to help you. You're allowed to hire any professional, right? To
okay.
assist you to
Yeah.
wind up the estate. So in this case, the
Yeah.
professional will be the attorney. And the attorney
Yeah.
will be getting, it's their fee. It's their tariff structure, whatever they say. They say, hey,
Yes.
okay, I can help you wind
Yes.
this up, but you must give me 10,000 rand.
Okay. All right. Okay. I hear you. Okay. Okay. We executor. Mm. All right.
Mm.
What
What's
else is
next?
in the wheel? In the
Okay,
wheels.
so you have um the executor. Then you have your assets, right? What assets do you
Yeah.
currently have?
Mm.
Some people like doing this thing where they just say all assets go to my children equally, right?
Mm.
and then
Yeah,
you
that's
don't
me.
specify. Yeah, you don't specify what exactly is going to who, and it doesn't matter what you have there.
Mm,
I never. It
mm,
doesn't matter. It's still going.
mm,
Some people are
mm,
very specific by saying, I want the house with this description to go here. I want my ring to go here. I want this, and then they word it like to the T.
yes,
Yes.
yes.
So, that will then you list your assets, and then second or third paragraph, you'll then list and say who gets what, right? It's very
Mm,
important in your will to have an executor, to have beneficiaries, because what's the point
mm,
of your will, right? In
mm,
your will,
mhm,
you don't make mention of policies. So documents that
mm.
you policies, sorry, that have beneficiaries already are not mentioned in wills because it already
What do you
has a
mean by that?
beneficiary. So, for instance, your pension fund,
Okay,
life
okay,
policies,
okay,
life
okay, okay.
policies. What else do they have there?
So if
What
I
else?
have a pension fund, what you mean is if I have a pension fund and in the pension fund I've already um highlighted beneficiaries,
Yeah,
then I don't have to say it again in the will
exactly.
because that could contradict. So if you maybe change.
Exactly. So what I'd also do is every time I consult with someone for a will, I ask them, is your beneficiaries in your policies updated?
Okay.
Yeah.
Mm.
That's where I'd start. I'd actually ask them that, is that, do you have insurance for your bonds if your properties are bonded? Because remember, at the end of the day, estate journey or the estate planning is not one route. It's a holistic thing. You must look at it,
Mm,
you know, as a holistic
mm,
journey that you're going through, and it's a holistic. You need to touch on every aspect. You know what I mean? Even in your will, for instance,
mm,
you can put things like who is your guardian for your children.
mm, mm.
You know,
Okay,
when you
before we
pass.
get to the guardian one, before
Yeah.
I want to
Okay.
know the guardian one because I have a question, personal question.
Okay.
Okay.
Okay, so it's assets, and then we can talk about we can add clauses like if someone is married, whatever they inherit from your will not be part of, your their or the beneficiary's joint estate. So if your son decides to get married in community of property, whatever he inherits will not be part of his in community of property. You can put that as a clause. You can put a clause that says, if your son becomes insolvent, right? He will not benefit from your will, even if he's a beneficiary, because it goes back to, remember, uh, if I'm insolvent and I know, hooray, no, I'm going to be reckless, knowing, hooray, if my mom dies, she's going to
Mm,
pay out all the
mm,
money that she's given me or she's made me inherit, will pay out
mm,
all my debt,
mm,
right?
mm,
And what do? You
mm.
just kill her. Just kill your mom.
Okay. Yeah.
You see,
Okay.
then yeah, I think yeah, those are the major ones. What's also important to note is that when people are married in community of property, you can have a joint will. So a
Okay.
joint will is, because remember,
Yeah.
in community of property everything is owned 50-50. Remember the bag of
Yes.
potatoes I mentioned in our previous meeting.
Yes.
Um,
Yes. Yes.
and then you basically are saying, if this one dies, you can mass
Mm,
joint estate,
mm.
so all of it goes to the next person.
Yes.
Yeah. So
Okay.
a will is
But
like
you
that,
still
a joint
specify,
will.
but you still specify your wish.
Yes.
You
No, but
still
it's a joint will, so it's your wishes together. If you want to do your
together.
own will, yes. So if you want to do your own will while you're married in community property, you can, but you'll just be talking about your 50% part of your assets that you're
Yes.
going to
Okay.
get, right? But has some, in community property, married people want to make it one, right? So they'll
Mm,
sign as one, as two
mm,
people that, hey, listen, we want our joint estates to go this way.
mm.
Yeah.
And then if one passes first, what happens to that will? Must it
Then
be updated?
no, then the whatever was decided in the joint will happens. So you'd get couples that say if one dies, everything goes to the children. That means the
Yeah.
other couple owns nothing at that point
Okay.
because everything gets transferred to the kids.
Okay.
Then you get a family or a husband and wife that'll say we have a joint will, whatever we have together gets massed into one, right? It's called a massing clause. So then what happens is that whatever, if this person dies, right, then it goes
Mhm.
and it's masked, and then that the other person that's alive gets everything.
Okay.
Yes.
Okay. Okay. On the beneficiaries, you said with the kids especially, I'm going to ask
Hmm.
for myself. So I have two boys, obviously. So now, what is the risk of not being specific? If you say 50-50, and you were saying, okay, you can be specific, you advise to be specific, but what is the risk? Maybe I'm trying to find a practical example. What happens then? Do they need to liquidate everything and then give them the cash, or what happens?
That's the risk. The risk is if, for instance, you have a property and you say 50-50, and one says, but I can't maintain the property. I can't maintain half of it. I want to sell my portion. They can sell it to someone else. Then one son owns half of the assets, and one's going to want to buy half a house, right? So then
Mm,
what happens is
mm,
that then it'll be a back and forth or a fighting position where one wants to sell, one doesn't want to sell. Then what?
I hear you. I hear you. And you can't say, okay, you get the house, we're going to look for something else of a similar value.
You can. No,
Probably
definitely.
you
They
can.
can. They can. That's where your executor needs to be smart. Because if it's 50-50, your executor can say, okay, this is how much the whole estate is worth. So if it's worth R1 million, right?
Mm,
But the reason why it's R1 million is because the house is 500,000 rand, the furniture, the jewelry, the cars is another 500,000 rand. Then the executor can say, okay, let's half everything. You'll get
mm,
the car, jewelry, and the furniture, and then you'll get the house.
mm.
That's fine.
And then there's the fight. I want the house. I don't want the jewelry. I guess that's going to be the fight between the two. Like, who then gets the house? Who gets the other portion? So I get you when you say be specific so that it just clears things
It
out.
clears definitely. Yeah. There's no up and down. There's no okay. But now what if mom wanted me to have that? No.
Mm.
Exactly. Ideally, they just co-own everything together.
Yeah, but then, like you're saying, if there's financial responsibility and then they don't all commit equally, and then it's another fight because now one is saying, but I'm the one paying, so I'm going to live here and I'm going to bring
Exactly.
my wife and children because you're not contributing and all that.
And then the other one says, "Oh, but you bring your wife and children in my house. It's my house too. So now
Yeah,
what does that mean?
it's my
I'm
house
I'm I'm,
too.
I'm housing your family. What about my family?"
Okay, I think I need that consultation. I need to read too much. I need to be specific.
You should be very yeah.
Okay, guardians.
Oof. This is a very sensitive one because um if you have children, minors,
Mm,
right? Um and you're a single parent
mm,
and the other parent is still alive
mm,
and you decide to put someone else as their guardian but not their father.
mm, mm. Are you even allowed to do that?
You can. You can. But the courts will always in this situation, and if the father of the children want primary residency of the children,
Mm.
right? And basically try and go against your will. They'll have to approach the courts because they were
Okay,
never
so I
there.
can I can choose my mother. I
Yeah, you
can
can choose your
say
mother.
the father's alive. I can choose my mother, and then if my mom is not happy about it, I mean, if my the father is not happy about it, then they can challenge my mother.
They can challenge your mother, yeah, and say no, but I'm the
Okay.
father. And the court will always look at the best interest of the children, right? So a man can't
Okay.
just come after 10 years and say, yeah, I'm back because your mother died. I'm gonna take you. No, they'll look and see. But where have you been this whole time? Do you even know what these kids have been
Yeah.
eating? Do you even know where they go to
Yeah.
school? Right? No, because at the end of the
Okay.
day,
Okay.
what
So
the
they're gonna
courts
have to challenge that in court.
exactly, and the courts will then decide and look at things like routine for the kids and where are they, what's going on, is this guy that's claiming to want to take and look after them a is he a sane person, is he responsible, there's a lot of factors that will contribute before they can say, okay, you are the guardian, take them.
Okay. 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 I think I had a different understanding, but that's great.
What was your
That's great. I
understanding?
think my understanding was that as long as the father is alive, they are the first people, the first person, or the other, whether it's the father or the mother, they have first right. Maybe
No, they have
doesn't
first rights. They have first rights,
does it
don't get me
override
wrong.
the guardian?
No,
Does it override the guardian? Okay.
what it does is that they have the first right, but they'll have to approach
Yeah.
the court to be
Okay.
able to get to start using that first right.
Okay. Yes. Yes. Yes.
So they
I
can't
get
just
that.
come and wake up in the middle of the night and take the children.
Mm,
Do you see? Like they can't just do that because the children are staying with your mother. Your mother, you specifically said you're the guardian. Uh, the executor will make sure that that's what happens. He'll apply for the necessary guardianship applications that needs to be done. He'll do all the work, right, to make sure that your mother's guardian
mm,
is the proper
mm,
guardian of the children and looking after the children and right. Then this man just comes and walks in and says, okay, I
mm,
want to take the kids now. No, then your executor will be able to, even your
mm,
executor will be able to go and tell him you can't take the kids. And then whatever court system that it'll
mm.
whatever court a direction needs to go, then he'll have to approach the court, or your executor approaches the court to say, this guy is here, he's coming to take the children, help me.
Okay.
Yeah.
Okay. Okay. I get you. What happens to step parents
What happens to step parents?
if they are not appointed as the guardian? It doesn't.
But look, you can approach the court for guardianship, right? Anyone can approach the court for guardian. If I've been looking after your kids, Lindiwe,
Mm,
for 10 years,
mm.
and this is an arrangement between me and you, right?
Yeah.
As or let's say you're married, your husband has been looking after the kids for whatever years, right? And he's the stepfather of the kids,
Mm,
right? And
mm,
you die,
mm,
and in your will you don't give him guardianship, right?
mm,
Because maybe
mm,
you did your will 10 years ago or 5 years ago before
mm,
you started dating this guy, right? Or before
mm,
you married this
mm,
guy, right? And he's
mm,
a step
mm.
parent, but he can
Mm.
prove, right, that he's been looking after
Okay.
them and it's the best interest of the children. There'll be a lot of investigations that be done, and at that age the kids are 10, right? So
Mm, mm,
10-year olds are a bit vocal, right? So they have what they call things like voice of the child. They have a lot of
mm.
like uh you know investigations that can happen. He can apply for guardianship.
Okay. But if you're not clear, then you're creating that,
Gap. That's the problem.
yeah, that space for
Mm,
now having to fight and have that whole conflict
mm,
situation. So what
definitely,
we're
yeah.
saying with the will is just be proactive and decide if
And be
they are going
direct.
to, and be
Be
direct
direct.
about
Be
you want
explicit.
them to be raising your children
Mm,
or not.
mm. And that's why it's also very important to always change your will when circumstances change. So
Like if
circumstances are
you break up
events.
or divorce.
Exactly. Breakup, divorce, one of your beneficiaries maybe died, if you have a new child, if you get married, if you buy a new property or acquire new assets, stuff like that. That's when your situation has changed. So now it means change your will. I remember I had a client that used to change his will every month. Ugh.
So what was going on? Buying new
No,
stuff.
no, it's just I think it's also emotional because if omongo kwatile omongo is like, it's fine, komunza. Then you'll just
Oh,
send, you'll just get an email. Kulu, take him off. I'm coming tomorrow to sign the new one. Oh, okay. so, so you can what you can change your will as many times as you want.
do you guys charge for that, for the changes?
Nah, look, no, we don't really charge for that. Like once you pay
Okay.
once, then if we, for instance, have your will when we store the will for you, we charge storage fee every year, right? So the storage
Mm.
fee will cover.
Includes amendments.
Yeah, exactly. So if you did your will with us last year, we'll do it again this week. We'll do it again this year. So for instance, most of the even the Wills Week individuals would like email them and
Mm.
say, "Hey, Wills Week is here. We're back. Do we want to change your will? Has anything changed?" They'll say, no, nothing has changed." "Oh yes, let's go. Let's revise it." Then they revise it. But
Okay.
if it's a change, nah, we don't charge for that.
Okay.
Mm.
Okay. How many do you need witnesses? How many people must sign? Can you just sign alone?
Two witnesses. Two
How many?
witnesses.
Two.
Two, mm. Two witnesses. They need to be over the age of 16
Mm-hmm.
and they need to be competent. They need to understand what they're witnessing. They need to be of sound mind.
Mm.
Um, yeah. And exactly what I just said now, those are the people that need to, those are the requirements of someone to draft a will. You need to be of sound mind. If you are, let me give you an example. I have a client who is a doctor, and he loves
Mm.
calling because he handles like terminal ill patients. He'll call and he'll
Mm.
say, "Hey, this patient is terminally ill. You need to come and help them do a will." First thing I'll ask is, are they
Mm.
conscious, right?
Mm.
And they say,
Mm.
"Yeah, they're conscious." I'm like, okay. When you speak to them, are they of sound mind? Can they hear and understand what you're saying? Right. So you say,
Mm.
"Oh, no, they can. Can they write?" Then they say, "No, they can't write." "Oh, no, but that's fine because you can sign with a stamp, right? So you can get like
Mm.
a fingerprint and stamp, but then that
Mm.
stamp needs to be commissioned by a commissioner of oath.
Mm.
That's another process as
Mm.
well. If you can't write, if you can't sign, right?
Mm. Mm.
Then you'd ask them questions like, are they how long are they able to be awake for? Because you don't want this
Mm.
thing where someone is writing and then they fall asleep, then they fall unconscious. That's when
Mm.
you kind of a bit, is this
Mm.
person really able to write to be conscious and tell me exactly what they want? Mm,
And remember what they said before they fell
exactly,
asleep.
exactly, yeah. So you ask
I
questions
get
like
you.
that, and then you'll be like, no, I don't think the person's of right mind. Um,
Mm.
you know, there's there's not, and obviously you as an attorney will be able to gauge, you'll be able to
Mm.
say, no, I don't think
Okay.
I'll be able to. mm.
Okay. Okay. Anything else on wills before we move?
Oh yes, power of attorney.
Mm. Mm.
Power of
Mm.
attorney when
Mm.
you die or when you are incapacitated, right? So in a hospital, in a coma, who gets to decide what happens to you financially and medically?
Okay.
You can put that into your,
Into your will.
yeah, your will can decide who your medical next of kin will basically be. You can go as far as even deciding what you want your funeral to look like.
Okay. Okay. It's sounding like, I don't know, but it's sounding like firstly, your executor could be one of the witnesses so they understand what the content of your will is because it gets difficult. Not really.
Your executor can't be your witness.
Okay. Okay.
Mm.
All right. I I don't know.
Your executor
All
can't be a
right.
witness. Yeah.
Okay. All right. Power of attorney. That's the person who decides
Yeah,
on
that's the person
critical
you can pick.
issues.
So your power of attorney can be your executor. You can say my power of attorney is my executor, or my power of attorney is I want my executor to nominate a second opinion doctor who will then
Oh, it
allow
can be.
and nominate my family to decide what happens to me if I'm in a coma.
Okay. All right. Okay, I think there's a question. As a housewife married in commute of property, can I state in my will how my 50% share of the estate should be distributed to my kids? I think we did touch on that to say
Yeah.
yes. And
Yes.
it's very important to be specific.
Mm. So your will
Okay.
in marriage, if you're married in common property, your will only define or talk of your 50%, not the entire joint estate. So yes, you can.
Yeah, so my 50, what happens to my 50%
Yes.
in terms of the kids?
Mm-hmm.
And this you can
Or
do
in
in the
terms of
joint will.
whoever. And then the
Yeah,
joint will is the two of you coming together and saying this is what we
yeah,
want to happen to our estate.
yes.
So joint
And
will, while you have a joint will, one of them can't stray from what was said in the will when either dies.
yes,
Yeah.
yes. Okay. All right. And last thing on the wills.
It's the funeral. I know I put the funeral thing at the end.
What about it?
Yeah, you can pick. You can decide how you want your funeral to look like. You can say I want to be cremated.
Mm,
I want to be buried. I know one client said they want to be buried on during the week. One said that they don't want their family to spend over 50,000 rand for their funeral. One said they want to be buried in a specific place. So yeah, there's different there's different things that you can use. Just like I said, just be specific and be detailed. That's
yeah,
it.
yeah, yeah.
Mm.
And then there's no fighting that can
Exactly.
rather,
Ooh, the family starts now. Oh.
yeah, the family starts, then they're like, ooh, why must we do this? And it comes with, it goes with the situation, yeah, organ donations, right?
Mm.
Oh, I was listening the other day, I think on radio, and they were asking people there to say, would you donate your organs when you die? Most of the people were like, yes, I would, but the problem is my family won't allow. So my question was, why is the family so involved in this decision? You know, and I think
Exactly.
even with funeral arrangements and preferences,
Mm.
we'll
You can
always worry
decide.
about what the family wants or how they would feel or what would make them happy. Or my
Mm.
parents won't like it if I'm cremated, or whatever. But you know exactly that you would like a specific order or a way.
Mm. No, that's true.
So, okay. So we're getting to what? Antinatural we did last time. Do you want to say anything?
All I can say is just revert back to our old video. Lindsay will put the link
I agree.
below. She'll put the link below so you can go and yeah, just mesmerize, massage your brain on different marital regimes.
No, I think that one stirred a bit, and that was good. That was good. Okay, so we will go to trusts.
Yeah. So trust is a entity where the founder decides or donates assets for the benefit
Mm,
of the beneficiaries. I'm not going to go into depth with regards to trusts because trusts are quite complex to go into, right?
mm,
But the only reason why you would donate assets into a trust is for number one, generational longevity, right? Number two,
okay.
tax uh, you know benefits, right?
Mm,
Number
mm,
three, yeah, I think that those are the two ones. But the problem with
okay.
the trust is that it's very, very expensive, not only to register, excuse me, but to maintain a trust. It's very expensive.
Okay. Tell us more. What do you mean? What is expensive?
Um, because you need to follow the compliance rules of maintaining a trust. So, for instance, you need to get your annual
Mm,
financial statement. You need
mm,
to have your meetings. If you're buying assets on the trust, under the trust's name, you need to do a resolution. It's a very administratively costing, exercise when you have a
Mm,
trust.
mm,
Because
mm,
end of the day, the trust should not be called or determined as a alter ego trust. An
mm,
alter ego trust is when you say, I want the tax benefits of a trust, but I want to run it as though the assets were mine and my own. And one of the benefits of the trust would be the tax benefits, right?
mm,
So then, because you want to evade tax, right? You
mm.
it's a trust. And then you run it like it's yours. You buy things, you go to Woolies and you reka groceries, and you're doing this, and you're buying assets because you
And is the
donated the
money
money.
that accessible? Is the money that accessible? It's not
Yeah, it's
even
just
locked up.
no, it's just a card. It's an account. It's an account. I don't know if they have
Oh,
cards. I don't know if they have cards, but it's on your app. Like you open your app and you'll see there your account is there.
mm,
Hmm.
okay.
But now the issue is, what are you using the money for? Because
Mm.
when it's there, it must always be for the benefit of the beneficiaries. Always.
So what would happen typically? So I can open a trust,
Hmm.
and then what would I put in it? Money,
You can put any
buy
because
assets.
you're what they call you're what because you're a founder and a donor. You're basically saying, I have this watch, right? I'm donating
Mm,
this watch to the trust.
mm,
Once that trust gets donated, once this watch gets transferred into the name of the trust, it's no longer my watch. Meaning I can't
mm,
wear this watch alone,
mm,
right? This watch no longer
mm,
belongs to me, it belongs to the beneficiaries. So the beneficiaries are the ones who can use the watch, who can charge the watch, who can maintain the watch, right? But all I do is manage the trust as an entity to make sure that everything assets, right,
mm.
are maintained, right, for the benefit of the trust of
Of the
the
beneficiaries.
beneficiaries. So I make sure that this watch is always working. I make
Okay.
sure it's always there's always a battery inside of it. I make sure that it's always clean. And
Okay.
cleanliness could be tax compliant, meaning I make
Okay.
sure
Okay.
the annual financial statements is done. I make sure that meetings are up to date, the yearly meetings, and but I cannot wear this watch because I can't benefit from it.
So beneficiaries access these benefits as you're maintaining. So they have immediate access. Or
Not
can you
immediate
set a
access, but
practice?
it depends. It depends what your trust constitution, which is a trust deed, says.
Okay.
When can they
Okay.
start benefiting? Can they
Yes.
start benefiting at what age? What age
Yeah.
are they able to start wearing the watch?
Yeah.
How long do they have to, or do they have to meet certain milestones before they can start wearing the
Mm,
watch? You know,
mm,
do they have to, do they have to earn certain salaries to get that watch? You can limit it. You can limit it, definitely.
mm.
Mm.
Okay. And when you die, you can instruct that a trust be open in your name.
Yes, so that's another aspect of a will, right? It's called
Okay.
a testamentary trust. In your will, you can
Okay.
have a paragraph that says, um, I have kids, right? My kids
Yes.
are minors. In the trust, in the will, you can say, I want when I die, I want my executor to register a trust and put all the assets in the trust for the kids.
Okay. How does that help
It helps with regards to, I mean, they're young. They're not going to be able to manage to inherit a
their
house
own?
at the age of 4 or 5, right? So the trust has it. The trustees look after the watch or the house, right? Knowing very well that the kids are going to benefit.
And you must, as the founder, you nominate the trustees.
Yes, you nominate the trustees who will do that. But they have no benefit to this watch. They are just there
Yes.
to make sure that the house is clean, the garden is swept, the roof is not leaking, but the people who are living in that house who are benefiting from it would be the beneficiaries.
Okay, Mara, then in real life, who are the trustees? It's the Rakhadis, who are they? Who then becomes the trustees?
Yes.
Who is
That's
it?
also that's also a very it's a very interesting question, because there was a judgment that came out a couple of years ago that you need to have a independent trustee as in your trust. An independent
As part
trustee.
of the trustees.
Exactly. So you have to
Yeah.
have, like, for instance, a minimum of three trustees, and one of them has to be independent. Independent is somebody that um, you're not related to, someone that is not a beneficiary. That person is just there to overlook, right? For instance, I'm an independent trustee of some trusts, right?
Mm,
Clients will
mm,
come and say, we have a family, we want to open a family trust. I'm like, okay. Then they're like, no, can you be our independent trustee? So I'll make sure, because whatever transactions move within the trust, all the trustees have
mm,
to sign, right? So me as an
mm,
independent trustee will be,
mm.
I don't think that's a good idea. Why? Because remember, I don't benefit anything, right?
Yeah.
So they will be benefiting as trustees because of the tax purposes, right? I'm like, that's not a
Okay.
good idea. And they'll be like, why? I'm like, because it doesn't benefit the beneficiaries. It's for
Yeah.
you. Then I'll be
Mm.
the person to be able to flag whatever red flag that needs to flag, And what do? I don't sign. If I don't sign, the transaction doesn't go through.
Yeah. Now I want to know who I'm Lindy. Who must I appoint now? I must appoint family members or
You can
friends.
appoint
Is that
anybody.
fine? Anybody.
You can appoint anybody. Literally, but it must be people you trust, because they're the ones who are going to make sure the watch is ticking.
You understand why I'm solving these problems with my child? There's issues. We can't
Mm.
be having issues with each other. There's important work that we need to do. Not
Exactly.
fighting as children fighting, siblings are fighting, parents are fighting. Who's gonna do all this work? Because
Hmm.
now you need people you
Now
trust. But
you hate all your family members. Now what? Now no
now
one
what?
sees eye to eye with you. Your friends don't speak to you anymore. So who's gonna be your trustee? But then you
Who's
can go
gonna
and
be
pick people.
executor?
You can go and pick the bank. The bank can do it for you. Get about it.
Mara, that's what I'm saying. Even who's gonna be your executor at the end of the
Mm.
day? Because you've got yeah. Okay. So we must fix our relationships. There's lots of work here. People need to sit on trust. They need to sign. They need
Mm.
to vote. They need to do. They need to be
Mm.
honest. They need to
Mm.
be. You
You need to make
understand?
sure your kids are
And
eating. They must make sure that their kids have guardians when they die.
you understand? The responsibility is too much.
It is a
Okay.
lot.
Okay. Anything to? So last time when we spoke, you said that sometimes when relationships go sour, then some people start opening trust to move assets in there. Is there anything more you want to say?
So, remember, trust is if I put something in a trust, I don't own it anymore, right? So, meaning that it doesn't get formed part of the in community of marriage, the trust, the joint estate, right? So, women or men, but actually, I'm just saying men because it's mostly men. They create trusts in order to basically remove whatever from the joint estate
Mm,
and be putting it in the name of the trust, right? But then remember, how the trust is run will determine, right, if that trust is an alter ego trust or if it really is
mm,
a trust for the benefit of the beneficiaries. So you come to me, you say you want a divorce. I'll say, okay, um, what does your partner have? No, no, he's got a trust. I'm like, okay, he's got a trust. What's the trust? What's his ID number? His ID number. Pull the trust deed. Okay, he's got a trust. It exists. Okay, let's ask for the annual financial statements of the trust and all minuted meetings, right? Because it's public information.
mm,
He's got none. He hasn't even the trust has been running for 5 years, but there's none of that. Ne?
mm.
Then you
Mm.
also see that, okay, can I see the state financials of this trust? But there's money coming into this trust, right? He's using it for whatever purposes, but not for the purpose of the beneficiary. Then I'm going to say,
Mm.
you know what? It's fine. We're going to use the value of the trust or the assets
Mm.
of the trust, and we're going to include it into your joint estate. So when your decree says, division of joint estate, we include the trust as well.
But can they even from the beginning just start moving assets without your
Yeah,
consent,
you
even
can.
if you're married in community of property?
Yeah, so that's the only, can I say, benefit of a trust. You can open one without the consent of of your
Of your
your your husband or wife when you're married in community of property.
okay, that's dangerous.
It is. But then if you have property and he wants to move the property that you guys co-own together into the trust, he can't do that without your signature.
Okay, so only things that maybe I own by myself, or wait, in my name, for example, or what?
No, it's things that he would acquire during the marriage, but he'll acquire them
Mm.
in the name of the trust.
Okay.
So if you're married in community of property, um, you guys have a home together, you guys both co-own the home. He wants to try and move the home into the trust, you'll need to sign, right? Because you're married in community of
Yes.
property,
Yes.
right? But if during the course of the marriage he decides that he wants to buy a car, but he wants to buy it in the name of the trust, right? He won't
Mm.
need your signature because he's not buying
Okay.
it for your marriage, he's buying it for the trust.
Okay. Using whose money? The marriage money to buy it for the trust.
You see, it goes back to that as well. What money did he use to donate to the trust for the trust to be able to use that trust account to buy the car?
Mm. Yeah.
Mm.
Okay. I think it's not gonna win. Okay.
It's not. There's ways you can make it win, but it's not gonna win the way you're explaining
Mm.
it.
Uh-uh. We'll be there asking the questions. Whose money did
Oh,
you use?
exactly. How did that money end up in there? How were
You
you
use
able
my
to just
children's
move?
money. It's my
Hmm.
children's money. We are
Exactly.
also part of the trust.
All of us. Good.
Hmm. Rasokodisa.
Ish, wena.
Okay. And then business.
Okay, yeah, so business is simple. It's just a succession plan. What is your succession plan? What is the plan when you have a business? Who's going to inherit, take your business? Who's going to look after your business after you die? This is all information that is in your MOI, the constitution of your business, the memorandum of incorporation. That'll determine what happens to your business when are no longer there.
Okay.
That's it.
I was talking
Succession.
about this. I was talking about this yesterday, I think. You know, but especially I think I was talking because somebody was saying they want to, or their parent who's already elderly wants to start a business, maybe like a chicken business, farming
Mm,
animals. So, and my worry was, you know what, because they are, so my comment, I think when we were talking and my realization was because normally these things, when, especially when you do it in the rural areas, they can really take up. They take off and the business booms. You find that yes, they're selling and you know there's progress. But the problem is they don't register the companies or anything because you think it's just a project for retirement and all of that.
mm.
And then there's a problem again when they pass on because there's no succession, there's nothing. It's kind of like the one
So you
person who
basically
was running.
you'd call that business, that person, it's a sole proprietorship then.
Yes, yes.
So
And
basically,
that's the issue.
then it belongs to you. Yeah, how? It's not a business. It's
Yeah,
yours.
how? Yeah.
Mm.
Yeah, how? And but then if I go and help my mom now to open one, what am I really saying? It's either me try and make formalize it. I think that's what we were saying. Either try and
Mm.
formalize so that there's success, there's a plan and there's
Yeah.
success because it will work, it will work. Believe it or not, it will boom. And then there's sales and there's everything. But then it's a one-person thing. And then this parent is like, oh
Mm.
my child, come, the business is doing so well. Come and help me work. I'm getting
Mm.
old. And you find that the kids are nowhere to be found not interested at all, and everything falls apart. And then here
Exactly.
again, there's no will, there's nothing, there's no registration of business, there's nothing. And
Ish.
then people come, but say dikgogo le dinku le ding tsa bofelo, and then that's it. Then the
That's it.
remaining family has nothing because maybe that was the income for either the wife or the grandchildren that are there, and then there's nothing. I think that just triggered that conversation for me to say,
I think that's, yeah, you are right. It is very right to formalize your businesses, formalize your agreements, um, formalize everything. Put it down.
mm,
Remember also when you're a sole practitioner, sole proprietor, it belongs to you, right?
mm,
So it's then going to be form part of your estate. Yeah, how?
mm.
Yeah. So whether those chickens are there, the value of the chickens will be taken, and then it'll then go into your deceased estate account.
Okay,
When you
okay,
have a
okay.
company, you would have determined what happens to your company, whether you want your partner in the business to buy you out, whether you want a another person to buy you out, whether you want
Mm,
your executor to continue your business. There's different ways
mm.
you can, but that was all mentioned in things like your MOI, your company MOI.
Okay, okay, okay. All right. And then if you married, what, and you are married in community of property,
Mm,
and then you open a business.
mm.
So what
What
must
does your
you
MOI,
do?
guys? What does your MOI say?
Okay, so that will be specified in there.
Yeah, your
Okay.
wife can claim, but like I said, what does your MOI say? Start there.
Yes. Yes,
Mm,
yes, yes. Okay. I think we've touched on all of them today because I was writing them down. Estate
mm,
planning, trust, we've spoken about wills and businesses.
yeah, I
Did
think
we
that's
leave anything out?
nothing. I think that's quite clear.
Yeah. Yeah.
Mm.
Text, we're gonna come back to this text story.
Ish.
I see it
Uh,
everywhere. Text benefit, text, text,
I
text.
think I'm not
If
the right
not you,
person.
someone else.
You
Yeah.
must get a tax practitioner to sit down.
Yeah.
Mm.
Yeah. I realize that now because it looks like it's everywhere. And I think it's something that most people, even me,
Don't
I wouldn't really
understand.
understand.
Yeah.
Yeah. Yeah. All right. Okay, Kulu.
Thanks,
Always a
Lindy.
pleasure to have you.
I'll see you soon.
Yes, I will see you soon. Soon.
Yes, next. I don't know what
When
our next
I'm,
topic. We'll figure out another nice topic. But this one was fun. I enjoyed this one. Enjoyed.
yeah.
Mm.
We love you here on Volts very, very much. And thank
Thank
you
you so
so much.
much. Thanks for
Okay,
having
babe.
me today.
Okay.
Bye. Happy estate
Bye.
planning.
I will, and I'll be calling.
I'll be waiting.
Sure.
Bye.